At age 19, Lenehan began working as a clerk for L.C. Elliot, who had taken over his late father's practice. Back then, it was common to spend 10 years as an article clerk and then to complete examinations and seek admission as a solicitor. Elliot was a drunk who was eventually struck off for misusing trust funds. He spent trust and office money on grog, and Lenehan was often unpaid. In short, as the High Court said, Lenehan underwent a very bad preparation for the profession of a solicitor and was employed where bad and disreputable practices were pursued and pecuniary dishonesty was commonplace. He himself, as clerk, engaged in some questionable practices, one where he unduly influenced his aunt to lend money, and another time when he took a cheque to pay back some of his wages. Consequently, when he sought admission in the 1930s, he was refused. He joined the army during the Second World War. He served with distinction in North Africa and was posted to high headquarters. He was in charge of regimental pay worth thousands of pounds a fortnight. He did this duty honestly, and after the war took up a position in the legal department of a bank, again handling large sums of money. In 1946, he applied again for admission, and again the Supreme Court rejected him. He appealed to the High Court, which split on whether to admit him. On the one hand, he really had shown himself to be of excellent character. On the other hand, could anyone be a solicitor who had ever misappropriated money? The majority in the High Court found that he was now fit and proper. They said there must be a strong disinclination to admit any person who has been shown ever to be guilty of improper conduct. It is a disinclination founded upon the unsafety of such a course and the need of strictness in maintaining the standards of the profession. But the false steps of youth and early manhood are not always final proof of defective character and unfitness. The presumption which they may appear to raise may surely be overcome by a subsequent blameless career. This often quoted statement tells us that the court has the discretion to forgive early misconduct if the applicant subsequently shows their commitment to the standard of professional conduct required of a solicitor.